Um, Dear participants to the HDIM, welcome. I welcome you to this morning's session number 4 on the rule of law that will cover protection of human rights and fighting terrorism, prevention of torture, and exchange of views on the questions of abolition of the capital punishment. Let me say a few words about the topics that will be covered in this morning's session. States are under the obligation to prevent terrorism, to protect human rights, and to uphold and respect human rights while countering terrorism. As recently as 2012, the OSCE Consolidated Framework for the Fight Against Terrorism identified the promotion and protection of human rights and fundamental freedoms as one of the strategic focus areas for the OSCE counterterrorism activities. Despite long-standing commitments, some of the participating states continue to implement security measures that undermine human rights. Actions taken by national authorities under unclear or expansive definitions of terrorism can stifle peaceful dissent, discriminate against ethnic or religious groups, or result in serious human rights violations, including torture, arbitrary detention, and the right to life. Emerging threats such as the increase in foreign fighters has led some participating states to prevent recruitment, incitement, and material support to terrorism through the use of measures that negatively impact the freedom of expression, assembly, association, and belief, as well as freedom from discrimination. Once again, I would like to stress that respecting human rights and countering terrorism are not conflicting, but mutually reinforcing goals. ODIHR has been tasked to offer participating states technical assistance in order to implement counterterrorism policies, which are fully compliant with the international human rights obligations and commitments. The recent publication, jointly with the OSCE Secretariat Transnational Threats Department, of the Manual on Human Rights in Counterterrorism Investigations and the Guidebook on Preventing Terrorism and Countering Violent Extremism and Radicalization that Lead to Terrorism, a community policing approach, for instance, are two milestones in fulfilling such a mandate. OSCE participating states have committed to prohibit torture and other cruel, inhuman, or degrading treatment or punishment. Participating states accomplished some important milestones between 2003, when the OSCE had its first supplementary human dimension meeting on torture prevention, and the first HDIM this year, when the same topic was revisited and stock taken of the progress. All OSCE participating states are now part to UNCTAD, which is doubtless an important achievement in terms of reinforcing state legal obligations to combat torture. 39 have ratified the optional protocol, and a number of these have well-functioning national preventive mechanisms. Still, there are tremendous challenges to be overcome. Ensuring prompt, effective, and impartial investigations and adjudication of allegations of torture in particular requires genuine political will and a concerted effort by all key players, including law enforcement, prosecutorial bodies, and the judiciary. Even when perpetrators of torture come to face justice, it is not granted that victims will receive redress. Finally, I would like to bring your attention to the recent release of ODIHR's background paper on the death penalty, which reports on developments relevant to the status of the death penalty in the OSCE area. The aim is to increase transparency in the application of the death penalty and promote compliance with international standards on the imposition of capital punishment. 51 of the 57 participating states have abolished the death penalty in law and in practice. 4 OSCE participating states introduced moratoria on the application of capital punishment, but retain it in law. And only 2 OSCE participating states continue to impose death penalty. The evolving international debate on the legality of the death penalty within the context of the right to life, the concept of human dignity, and the absolute prohibition of torture, inhuman or degrading treatment or punishment, calls for renewed discussion on the subject. It is also necessary to consider the impact of the death penalty on children who have a parent facing the death penalty or executed, and ensure that OSCE nationals facing capital punishment in other countries fully enjoy the relevant human rights safeguards, including the right of a trial and the prohibition of torture and the prohibition of discrimination. With this, I would like to now introduce the main speaker of today's session. Sitting to my left, Mr. Gerald Staverok, born in Germany in 1968, who is the Secretary General of the World Organization Against Torture since September 2011. The World Organization Against Torture is working towards the eradication of torture and the protection of human rights defenders globally. Previously, he served over 8 years with the International Commission of Jurists, including as director of its Center for the Independence of Judges and Lawyers, and as director of its Global Security and Rule of Law Initiative. In this context, he coordinated a global inquiry on the impact of counterterrorism and human rights through a high-level panel of jurists. From 1998 to 2002, he worked at the OSCE Office for Democratic Institutions and Human Rights in Warsaw, coordinating rule of law and anti-torture projects, including prison reform projects in Eastern Europe and the former Soviet Union. He's a qualified lawyer from Germany, concluding his judicial clerkship with the Higher Regional Court of Berlin. He studied in Bonn, Geneva, and Washington. He has published on issues of the rule of law in transition countries, the domestic implementation of international standards, counterterrorism, and human rights, including on the lack of accountability over intelligence agencies and cooperation, and on the role of civil society in international law. We're very much looking forward to listening to what he is going to share with us today. But before that, let me introduce you to the moderator of this session, Ms. Bokulic, who is head of the Human Rights Department in our Office for Democratic Institutions and Human Rights of the OSCE. In addition to human rights monitoring, in particular of freedom of assembly, her work includes human rights capacity building with a focus on law enforcement, national human rights institutions and human rights defenders, engagement with the security sector on human rights and gender issues affecting security sector personnel, and support for human rights compliant anti-terrorism policies and practices. Prior to joining ODIHR in April 2010, she worked for Minority Rights Group International and the Open Society Institute. Her work focused on strengthening the capacity of minority rights NGOs to advocate at intergovernmental human rights fora, including the UN, Council of Europe, OSCE, and the African Commission, and in particular on improving the participation of minorities in EU development and accession processes. She has published on topics such as audit monitoring of freedom of assembly, engagement of ODIHR with civil society, political participation of minorities and minorities in the EU accession process in the Western Balkans, among others. With this, I would like to pass the word on to Snežana, the moderator of this session. Thank you.
Thank you, Beatrice. Good morning, ladies and gentlemen. Welcome to this fourth working session of this year's Human Dimension Implementation Meeting. The topics to be discussed in this morning session are protection of human rights and fighting terrorism, prevention of torture, and we shall also exchange views on the question of abolition of capital punishment. The speakers list for this session already has 40 names. So if anybody else feels very strongly they should be on the speakers list, the time to put your name down is now, because the speakers list will be closed. And I would now like to turn to our introducer. Gerald, the floor is yours.
Thank you very much, and thank you for the invitation to introduce, in fact, 3 topics that are different but also are interrelated: torture, death penalty, counterterrorism. Now, coming from the World Organization Against Torture, which is effectively a civil society coalition fighting torture in various parts of the world and in all regions of the OSCE, you will not be surprised that I intend to address the issue from an anti-torture perspective on all of these 3 counts. Like many of you, this is not my first Human Dimension implementation meeting and discussion on torture. Like many of you, we have seen anti-torture reforms for about 15, 20 years within the OSCE. And there's always a risk in sessions like that we fall into a sort of routine and do what we usually do, and we discuss torture prevention in rather abstract terms. My first suggestion to you is taking stock as a key task in the OSCE. We have been working for 20 years on anti-torture reforms. The real question is, where are we now, what has worked and what hasn't worked? So I think we should use this as a sort of stock taking. I then looked into what are key elements for me in the stock taking of the successes and failures? And the first one, I think, is we have to set the right agenda and an ambitious agenda for the OSCE when it comes to eradicating torture. And I would suggest that we set the target not prohibiting torture under law, which is nice, but real eradication. It is for me struggling to understand that we have torture as one of the most prohibited norms under international law. In times of war, in times of peace, non-derogable, erga omnes, jus cogens, a crime under international law. You cannot have more. And yet, unlike slavery with a similar status of law, and I let aside the issue of slavery-like practices like trafficking, etc., we have not eradicated torture. We have not even come close to eradication of torture. So my first proposition to you is maybe next time when we meet here, we should call this session on the eradication of torture and how the OSCE region can be the first region that eradicated and not only outlawed torture. And for that, I think we have to look into the approaches that we are taking. And I think the core of that needs to be a holistic approach to torture, and I will come back to that. We are celebrating this year the 30th anniversary of the Convention Against Torture, a baseline consensus, a blueprint on how you eradicate torture across the globe and including in the OSCE region, and as you said rightly, a document ratified by all of us, or all of you as states participating in the OSCE process. I think we have to do more to implement that convention. What could that mean for the OSCE and OSCE participating states? Well, if we look at the OSCE region, one of the virtues it had over the last 20 years is experience on internalizing international human rights law domestically. If you take the processes that went underway, internalizing the European Convention on Human Rights, scrutinizing legislation for compliance, we have a lot to offer in the OSCE region, and we should apply it vis-à-vis the Convention Against Torture to fully integrate it into domestic law and policy. Also, we have the Committee Against Torture, which is the authoritative body when it comes to implementing the Convention Against Torture, and I think we have to give much more emphasis to the recommendations of that committee. And we have to carry the deliberations of that committee back into the countries, because the purpose of it is not to satisfy administrative needs in Geneva, but to make an impact on the ground. In line with the Russian proverb, if I'm not wrong, that every new good is a long forgotten old, I would encourage ODIHR and the OSCE field missions to play a role in bringing civil society and government systematically together about 6 months after a report and recommendations have been issued on a country, which was a practice a couple of years back and which was quite effective in triggering domestic reform processes or reinforcing them. Also, I think we have to think of, with modern technology, we can bring the hearings into the countries. We can webcast them in the country, organize hearings on the ground with stakeholders on the Convention Against Torture and the Committee Against Torture's hearing. OMCT is exploring that, and we are happy to provide that expertise and partnership to the OSCE if so wanted. But the real question is indeed follow-up to implementation of the Convention Against Torture and the Committee Against Torture. The next point for me is a point that I find a little bit forgotten in the OSCE response to torture. Torture is about laws, about policies. Torture is about the effect it has on the rule of law, that it distorts the institution, that it corrupts. But torture is about victims, about individuals. Torture is a horrendous crime. Torture is an enormous cruelty in many ways. It destroys lives. We internationally say that there needs to be always a victim-centered approach. Sometimes in the OSCE forum, I feel that the victim-centered approach is missing. We are talking about abstract laws. We're not talking about the rights and needs of victims of torture, which include talking about justice, talking about reparation, talking about rehabilitation. So in whatever the future response of the OSCE to torture will be, I would strongly encourage to set also a victim perspective into this. It is not an abstract evil, it is concrete, it destroys lives. The next point is, for me, legal and institutional reforms are fundamentally important, but they're not enough. When I look at the OSCE region and the work we've done over the last 20 years, I see an enormous amount of new laws, new policies, new institutions, and we continue to go that path. And to some extent, it's very comforting. It gives us the feeling that we are progressing. But we have to ask ourselves, are we indeed progressing? Now, nobody will doubt that we need effective preventive safeguards. Nobody will doubt that we need effective judicial control over detention. Nobody will doubt that it is fundamental and a key role for the OSCE to support that those who detain are separate from those who interrogate. Nobody will doubt that we need national human rights institutions and so forth. But we have also to look into the quality of what it produces in actual torture prevention and redress. We have numerous examples in the OSCE region where certain powers have been given to the judiciary, but it hadn't the effect of effectively safeguarding people in detention. When I came here in the plane, I got a note on a report apparently issued by the Kyrgyz ombudsman about the use of the judiciary restrained competences, which A, showed that there's a very low number where it actually intervened into decisions of the Procuratura, and B, suggested that where this was the case, it is more a question of corruption and where money is allocated rather than a qualitative control mechanism to prevent abuses in detention. This is just one example. To be clear, if the judiciary is controlled independent and not fully independent, it will not question executive powers, and we will have a safeguard that looks good on paper, but it's a formal rule of law, it's not a substantive rule of law. To be clear, we want the criminalization of torture, and some OSCE participating states, including the country of the chairmanship, still has to do it. But what matters is not so much criminalization. What matters is that we investigate and prosecute. And here I think we have to have a little bit of a sea change in our approach in the OSCE region. Yes, we need those reforms. We need to continue. But it's qualitative. It's not a formal legality that we need. And unfortunately, we often got formal legality. In a similar token, national preventive mechanisms need to prevent. It is an enormous potential that we have in the OSCE region, and you mentioned the number of states that have ratified the optional protocol, that we now have a mechanism that quite uniquely links an international mechanism of enforcement with a domestic enforcement mechanism. That needs to be supported. But we should learn the lesson also that we did in the OSCE region with creating national human rights institutions and human rights ombudsman institutions, a good number of which has not lived up to the expectation because they were not made independent, they were not properly resourced, and they didn't really have impact. So when we create national preventive mechanisms now, we should do it right. And we should ensure that they're properly resourced and independent. And if they are not, maybe it's better to wait. We see with concern that a good number of national preventive mechanisms that are presently created don't live up to that expectation. We even have in Western Europe, if I look at my own country, Germany, we have a dramatically under-resourced and ill-equipped national preventive mechanism. Switzerland has a very good functioning mechanism because there are very good people doing it, but it lacks financial autonomy and institutional independence. And we have seen in the past in Central Asia and the Caucasus a lot of underachieving national human rights institutions. Let us not create underachieving NPMs, let us create fully independent and effective ones. In any case, national preventive mechanisms are fundamental, but they are not alone sufficient to address the issue of torture. And here I come to a couple of points that I think are a little bit missing elements in our global or regional anti-torture strategy. And the first one is a difficult issue, but a fundamentally important one: accountability. I think it is an illusion in our experience to think that we can prevent torture if we never ensure accountability. And accountability means remedies and reparations for victims and responsibility for those who are responsible for torture. I see very few, if any, examples in the OSCE region, and I'm happy if delegations prove me wrong by naming 2 or 3 cases of their country where people have been actually held account for torture in their countries. And I think this is an area where also the OSCE and ODIHR should explore more. We have some promising signs. In Russia, for example, there is a special investigative mechanism that had been created about 2 or 3 years ago for serious crime, including torture. We need to make that work, then it could become a model for other countries in the region. Unfortunately, initially the first investigation that this body has undertaken was not on torture, but investigating the country's leading human rights activist working on torture, Igor Kayapin. But it is the right approach. We need truly independent investigative mechanism that can break the corporate veil and the core spirit that prevents accountability. And I think also in the OSCE we have to work with prosecutors. We have a situation in many parts of Eastern Europe in particular where prosecutors have seen or perceived the human rights agenda as something hostile to them. I believe strongly that you don't have to be a human rights activist like me to think that torture needs to be prosecuted and investigated. You need to be a prosecutor with ethical standards that this is a crime, and the fact that it is a crime by the state doesn't make it more leniently to be treated, but makes it much worse. The logic of I'm a prosecutor, therefore investigate torture needs to be reinforced, and we have to create a pool of prosecutors in various countries, work with them on that issue. Another element that I think we've neglected in the response to torture is building constituency for torture reforms. Torture can be a technical issue, and it needs to be discussed on a technical level with professional groups, etc. But we need to generate more public support that rejects torture and that supports active anti-torture reforms. We have to reach out to the public in this. And in that regard, we have a key constituency, which is civil society. If you look at the effectiveness of human rights treaties, the Convention on the Rights of the Child, CEDAW on women's rights, CRPD on disabilities, it is that it allows a platform building of civil society on the basis of these treaties. We have to allow the same thing when it comes to torture. We have to encourage civil society, we have to enable it, we have to create and support national coalitions against torture. And it is absolutely clear to me that we cannot on one side say we will progress in the fight against torture by certain legal institutional reforms, while we at the same time go against human rights defenders working on torture. One case that was mentioned yesterday that I would like to mention because it is a member of my General Assembly at the OMCT, Leila Younas, who is presently in prison. But we have multiple cases where defenders are incarcerated, where they are arrested, where organizations are prevented from working on torture. And I think it's important. Human rights organizations on torture have specialized expertise that can be a tremendous value for states. And even where they hurt or irritate sometimes states, they are fundamentally needed because we need organizations that can document and report on torture. We need that they provide services to victims of torture, and that they hold governments to account. That's their right and responsibility, and I think if we are serious about fighting torture, this civil society support is equally fundamental. But let me now turn to the two other issues very briefly that are on the agenda, and I will do so from obviously a professional misformation as a anti-torture activist. Counterterrorism. I'm not telling you anything new that after 9/11 we've seen one of the biggest erosions of the absolute prohibition of torture in the context of counterterrorism. I'm also probably not telling you anything new that I think there's no question of a doubt as a human rights lawyer that we want terrorism to be addressed, but we want to be addressed within the rule of law and not as an abrogation of the rule of law. I think we have made progress over the years. OMCT participated, for example, in the Interlaken conference this year, I think as the only anti-torture organization. But that type of participation, bringing the different strands of security dimension and the human dimension together, is fundamentally important. We've made progress in having today a discourse and a certain acceptance that human rights actually matter in counterterrorism. I think what is the missing link, what we haven't achieved yet, is to convince people that the human rights framework is a positive contributor to the fight against terrorism. It's not the add-on limitation, it's a positive element of fighting terrorism. And the history is replete with examples where abusive, arbitrary, or unaccountable policies on counterterrorism had devastating long-term effect, not only on human rights, not only on the rule of law, but also on the effectiveness of fighting terrorism. So we have to make human rights an active component, not only a limiting factor in countering terrorism. But the other thing that is key is the word accountability. What do I mean with that? Three things. One, we need accountable legal frameworks when we deal with counterterrorism. Many counterterrorism laws historically have the tendency, and the pressure is high in countries to react to the threat of terrorism, to reduce safeguards, to create an environment that is prone to torture. And we know that torture is rarely coincidental. It is usually the result of creating a permissive environment that leads to abuse. So we should take stock, and ODIHR should help in that, in reviewing some of the counterterrorism legislation adopted over the last years to ensure that they are effective safeguards against abuse, including torture. Second, accountability means actors are accountable, legally and politically. And here, you mentioned earlier the issue of intelligence accountability. Obviously, we have seen post 9/11 a whole shift from a law enforcement criminal justice paradigm to an intelligence-led response to terrorism. We need intelligence. We need intelligent intelligence. And one of the key elements that we have to ensure is if we give new powers to those actors, that the oversight and control mechanism in a democratic society have to grow accordingly. The rendition context has shown very sharply the failure of oversight mechanisms to control, and the failure to address the issue of international intelligence cooperation, which has largely led also to the sharing and using of torture-based information in violation of international law. So, I know this is a complicated and difficult issue, but if anybody, it should be an organization with both a security arm and a human dimension arm trying to tackle that difficult issue. But accountability is not abstract. It's also about legal remedies and responsibility. And one of the most disturbing elements about what happened in recent years is that we have what you could paraphrase as we have accounting, but we don't have accountability. We accept that there was a policy of torture in the United States, but we don't have accountability. And there's a perception, well, this is something of the past, let the ghosts of the past be calm. We work globally. We are constantly reminded of double standards arguments. We are constantly reminded that the duty to investigate and to end impunity is a core function of what the absolute prohibition of torture is. And if we don't, we do a crack in the very foundation of the absolute prohibition. And we also create a situation where we say effectively, well, victims, they matter to us if they are sympathetic and nice victims, ideally treated badly by another country but not by us. But when they are not sympathetic, then it's a different ballgame. The very notion of the absolute prohibition is we don't distinguish between who is the victim. Whether it's a criminal suspect, whether it's somebody we like or we don't like, it does not matter. So we have to ensure accountability, and the damage that has been done has not yet undone. The death penalty, very briefly, you will not be surprised that as an anti-torture organization, we inherently believe that the death penalty violates the prohibition of torture, cruel, and inhuman treatment in its basis. I'm obviously aware of the policy framework in the OSCE and the limitations that exist within. One thing that really worries me, or maybe two things that worry me from my professional background is sometimes we establish moratorium or similar things. That's great, but we also then have to reform long-term detention of people, not to create inhuman degrading treatment through this type of detention regime applicable either on death row, on a moratorium, or lifelong imprisonment. So if we go one way, we have to go the second way. The other point is the issue of Belarus executing people almost systematically at a time when the UN Human Rights Committee has issued interim measures, and the type of execution which says that the family has no right to know that execution takes place, when and how and where. The body is not buried in a place that is known. It reflects a mentality that we want to eradicate this life. We don't only want to end this life, we want to eradicate that this life existed. And that in itself is, for me, a violation of the absolute prohibition of cruel and inhuman degrading treatment. Coming back to the beginning and conclusion, I think we need a new agenda in the OSCE on torture. Torture is the number one baseline consensus that we should have when it comes to the human dimension. And even in a time where we have erupting differences between East and West in the OSCE and globally, this should be the number one consensus we maintain. Torture can never be accepted. We all agreed. And we all agreed and know what the measures are we have to take. So allow the OSCE and also ODIHR to play a role in that anti-torture agenda for the future. I think there are very good examples with a special focal point on Roma and Sinti, trafficking, others. I think it's time to establish something similar in the OSCE, ideally with an ODIHR. It is also maybe time to resurrect what existed some years back as an advisory panel on torture, which effectively paved the way for similar panels in the ODIHR itself, to give new impetus to the fight against torture. 30 years of the Convention Against Torture, we have the choice. Do we accept that torture will continue to be acceptable somehow in our society, or do we now say we make the OSCE a torture-free place? I thank you for your attention.
Thank you, Gerald, for your insightful and thought-provoking remarks. You have indeed set an ambitious agenda for this working session. I was particularly pleased to hear that your remarks echoed a lot of the discussion which we had earlier this year in April at the Supplementary Human Dimension meeting in Vienna, which discussed the prevention of torture. Thank you also for providing the framework for the discussion this morning, in particular for your innovative suggestions and recommendations. We have taken note of them. Now, we take your points on NPMs, the National Preventive Mechanisms, and the need for them to be effective and properly resourced. We certainly take your point on accountability and its fundamental role in preventing torture, because otherwise it's counterproductive and a self-defeating effort. Also on the importance of civil society to enable coalitions of civil society working against torture, and on the need to protect human rights defenders, especially those working on torture. This was also something which was echoed and discussed at the Supplementary Human Dimension meeting. In terms of counterterrorism measures, your point that any such measures need to be within rule of law and human rights and not outside, I think this is still very relevant for the OSCE region. And also the issue, thank you for reminding us of the double standards in many ways, because that's another challenge in implementing human rights and implementing international human rights law. So I pause here and we will proceed with the discussions and interventions from the floor. Now, my speakers list has 41 speakers. It is now closed. We have 3 minutes allocated to each speaker. I will have to be strict in enforcing the time limit, both in the interest of fairness and equal opportunities for all speakers. We are time bound because the interpreters have to finish at 1 p.m. So please help me in ensuring a smooth flow of the discussion. There will be time allocated at the end for the right to reply. So we shall make sure we take care of that. After the speakers have been given the floor, would you kindly introduce yourself, the organization or the delegation you represent? I would kindly ask you not to read prepared statements. They can be shared and distributed via the documents distribution system, and they will be made available to all participants in this meeting. Focus on recommendations. Do emphasize the recommendations. They are quite an important part of this discussion. And keep your comments brief and to the point. Of course, constructive criticism is welcome. So I would now like to turn to the first speaker on my speakers list, which is Denmark on behalf of the EU, to be followed by the United States of America. Denmark, the floor is yours.
Thank you, Ms. Moderator. I am honored to speak on behalf of the European Union. The following statement is also on behalf of Albania, Andorra, Bosnia and Herzegovina, former Yugoslav Republic of Macedonia, Georgia, Monaco, Norway, Liechtenstein, Montenegro, San Marino, and Ukraine. Please note that this list of aligned states is not final. The full list of aligned states will be provided on the written version of this statement. The rule of law is one of the fundamental principles upon which the EU is founded. A key objective for the EU is therefore to strengthen the rule of law both at international and national level. The EU also wants to draw attention to the 2012 UNGA resolution on the rule of law at the national and international levels, which reaffirms that human rights, the rule of law and democracy are interlinked and mutually reinforcing, and that they belong to the universal core values and principles of the United Nations. The EU recommends that all states who still practice the death penalty or retain it in law abolish it. The EU holds a strong and principled position against the death penalty, and abolition is a key objective for the EU's human rights policy. Capital punishment is cruel and inhumane and has not been shown in any way to act as a deterrent to crime. Furthermore, any miscarriages of justice could lead to the killing by state authorities of an innocent person. As far too many individual cases have demonstrated, wrongful convictions do occur and innocent people are put to death. The EU strongly and unequivocally opposes the death penalty at all times and in all circumstances, even when backed by due process in a democratic society. The cruel, inhuman, and degrading aspects of the death penalty are not mitigated by a democratic process. We are encouraged by the growing momentum towards abolition, but we are not complacent. The EU will therefore continue its long-standing campaign against the death penalty, including within the OSCE, and we regret that 2 OSCE participating states, Belarus and the United States, so far have not followed the global trend. As a first step towards abolition, the EU advocates a global moratorium on the use of the death penalty. The EU therefore encourages all OSCE participating states to support the 2014 UN resolution on a moratorium on the use of the death penalty, which will be tabled in October during the 69th UN General Assembly. In the fight against torture, the EU recommends that a full toolbox of measures should be applied. Like capital punishment, torture can never be justified. Torture and ill treatment are forbidden under international law in all circumstances. They are among the most abhorrent violations of human rights and dignity and should be eradicated. The fight against torture should cover all aspects, including prevention, rehabilitation, and bringing the perpetrators to justice. The EU therefore urges all OSCE participating states to implement fully the United Nations resolutions against torture and to give strong consideration to ratifying all international conventions and protocols on torture, as well as those relating to the death penalty and enforced disappearances. Independent national preventive mechanisms monitoring the conditions of people deprived of their liberty are considered a particularly important preventive tool. The EU therefore encourages all states to establish such mechanisms in line with the optional protocol to the Convention Against Torture. It is of grave concern to the EU that torture and ill treatment continue to occur, even in OSCE participating states. The EU therefore strongly supports the Swiss chairmanship in prioritizing the issue of torture, and we welcome the supplementary Human Dimension implementation meeting held in April 2014 on the topic of torture, as well as the useful recommendations put forward on this occasion. We strongly encourage a continued focus on the issue of torture in the OSCE's work, including within ODIHR and OSCE field missions, given the continuing violations across the OSCE region. The EU is convinced that human rights protection and the fight against terrorism should be seen as complementary rather than contradictory. Effective counterterrorism policies and the promotion and protection of human rights are mutually reinforcing. The position of the EU is that while terrorism should be prevented and combated with the means of the criminal justice system, the respect for the rule of law and fundamental rights and freedoms should be fully respected and promoted. We commend the efforts of the OSCE in providing support to states to ensure respect of human rights in countering terrorism and believe these efforts should be expanded further. Thank you, Ms. Moderator.
Thank you, Madam. The floor now goes to the United States of America, to be followed by Switzerland.
Thank you very much, and I want to start by referring you all to a release that we'll put out today on a speech that President Obama gave yesterday on civil society. There were several specific references to problem areas that have been discussed here in that speech, so I recommend that all states take a look at that speech. I want to welcome the comments that were made by the keynote speaker here this morning on torture. This is a very, very difficult issue, and I think everyone understands how difficult it has been in the United States, particularly in that period after 9/11. On the issue of accountability, the Intelligence Committee of the U.S. Senate has been looking into this issue. They hope to release a report. There's been a negotiation over what should be in that report with the intelligence community. But I think when that report is released, this will be a very important step toward accountability. It's quite clear that torture does not produce intelligence, as you said. And there have been many, many efforts made by NGOs, including people within the U.S. government, that have made that point. Alyssa Messamino, who spoke here for human rights first in the opening session, has gathered a group of military officers who have testified on Capitol Hill saying that torture does not indeed produce intelligence. My wife works for the Center for Victims of Torture in Minnesota, and it's also been strongly advocating against torture of the type that we have recently seen. While there are many, many reasons why my government has to really look introspectively at this issue, given the reaction to 9/11. I think we're moving in a very different era at this point. Indeed, I think it's important for us to begin to not just be on the defensive, but to indicate that there are other instances within the OSCE where torture has taken place, where people have actually been killed in prison. And the prepared statement here that we've offered gives several examples of that, including in the eastern part of Ukraine, where the de facto authorities in Russia-occupied Crimea have been committing torture and abusing rights. The Ukrainian government's commitment to work with Amnesty International is welcomed. In Tajikistan, there is a very well-known case where a person clearly was tortured and died trying to escape the prison hospital. The Tajikistan Ministry of Internal Affairs announced in November that an investigation was launched into charges, but we haven't heard any results from that. In Uzbekistan, we have some very serious cases of alleged torture. I want to first emphasize on the issue of the death penalty my personal position on this. I'm here representing the United States government, and all of the points have been made about the fact that due process is followed, that there is no OSCE prohibition against the death penalty. In fact, there's no international legal prohibition against the death penalty. My personal position is that it's immoral. It is cruel and unusual punishment, in my opinion, but that has to be decided by our Supreme Court. And I and many, many Americans will fight for as long as we can to make sure that we have changes. And in fact, many states have abolished the death penalty. Cite New Jersey, New Mexico, Illinois, Connecticut, and Maryland. But it is a process, and we hope that with some international, I hope personally, with some international pressure, that we will come to a point where we will no longer have the death penalty in the United States. I think the bell has rung at an appropriate time. I will end my conversation.
Thank you, sir. I'm glad we have coordinated that well. I now give the floor to Switzerland, to be followed by Norway. Sir, the floor is yours.
Merci, Madame la modératrice. Malgré le caractère impératif de l'interdiction de la torture et autres peines ou traitements cruels, inhumains et dégradants, de tels actes subsistent aujourd'hui dans l'espace OSCE. Si tous les États participants sont partis à la Convention des Nations Unies contre la torture, la mise en œuvre des obligations est relative et lacunaire et doit être effectuée. Fort de ces constats, la présidence suisse de l'OSCE a souhaité remettre la lutte contre la torture à l'ordre du jour de cette organisation en vue de développer de nouvelles réponses contre la torture et en particulier sous l'angle de la prévention de tels actes. La Suisse se réjouit de l'engagement des États participants constaté jusqu'alors dans les discussions et des contributions substantielles d'experts d'autres organisations internationales et des membres de la société civile. Ces derniers sont des acteurs indispensables d'une prévention adéquate de la torture, notamment par le biais de leur participation à des mécanismes nationaux de prévention respectant les critères d'indépendance requis. Les discussions ont également souligné la place stratégique des institutions de l'OSCE et la nécessité d'amplifier leurs activités dans ce domaine. Le projet de décision ministérielle présenté par la Suisse reprend ces points et nous appelons les États participants à un engagement constructif en vue de son adoption à Bâle. En ce qui concerne la peine de mort, la Suisse dénonce la poursuite des exécutions dans 2 États participants, notamment du point de vue des violations des droits de l'homme commises dans ce contexte, entre autres eu égard à l'interdiction absolue de la torture ou au droit à un procès équitable. Elle s'inquiète de l'inscription de la peine de mort dans la législation de plusieurs États participants, rappelant que cette sentence ne contribue pas plus à la prévention du crime que d'autres sentences lourdes, y compris en ce qui concerne des actes terroristes. Sur ce dernier point, la Suisse rappelle que le strict respect des droits de l'homme et du principe de l'état de droit est fondamental dans la mise en place et l'application de mesures antiterroristes. À cet égard, la Suisse salue l'adoption hier à New York par le Forum mondial de lutte contre le terrorisme de nouvelles recommandations sur l'utilisation des renseignements dans le cadre des enquêtes et poursuites terroristes, qui affirment le droit à un procès équitable et l'interdiction de la torture dans ce contexte. Je vous remercie.
Thank you, sir, for your remarks and also for keeping the time. The floor now goes to Norway, to be followed by the Russian Federation. You have the floor, sir.
Thank you. I speak on behalf of France, the Netherlands, and Norway. This morning, we co-organized a side event on enforced disappearances in the OSCE region. The event was co-sponsored by Albania, Bosnia-Herzegovina, the European Union, Iceland, and Moldova. We heard presentations by Professor Manfred Novak, former UN expert on disappearances and former UN Special Rapporteur on Torture, as well as statements by representatives of ODIHR and the Council of Europe. We heard testimonies from victims of enforced disappearance from Turkmenistan and Ukraine. This gave us a solid basis for reflection on the international instruments at our disposal in the fight against this inhuman practice, as well as on our international obligations in this regard. The full text of our statement will be circulated in writing. Now, I will limit myself to 3 points. First, enforced disappearance continues to occur in the OSCE area. It often leads to torture and other ill treatment. It not only affects the disappeared person, but also his or her family, friends, and the society they live in. Such disappearances constitute serious violations of human rights and of OSCE commitments. Second, in 1992, all OSCE participating states adopted the UN Declaration on the Protection of All Persons from Enforced Disappearance. We committed ourselves not to practice, permit, or tolerate enforced disappearances, and to take effective legislative, administrative, judicial, or other measures to prevent and terminate acts of enforced disappearance. In addition, 33 OSCE participating states have signed the International Convention for the Protection of All Persons from Enforced Disappearance. Third and final point, the lack of specific OSCE commitments to prevent and combat enforced disappearances is a serious gap that should be addressed without delay. The topic of the prevention of torture, which is on the agenda of the Ministerial Council this year, is an opportunity to close this gap. Thank you very much.
Thank you, sir. The floor now goes to the Russian Federation, to be followed by the United Kingdom. You have the floor, sir.
Уважаемый господин председатель, уважаемые участники заседания, представляю российскую делегацию. Сегодня в СМИ появилась информация о том, что ополченцы под Донецком обнаружили массовые захоронения гражданского населения. У найденных были связаны руки, у некоторых отсечена голова, обнаружены выстрелы в упор. Там же найдено тело беременной женщины. Обнаружены тела казненных ополченцем со следами пыток. Возмущены этим свидетельством противоправных действий силовых структур Украины. Требуем тщательного расследования и подключения к нему представителей ОБСЕ. Как показывает практика, без участия международных структур рассчитывать на беспристрастное расследование украинских следственных органов невозможно. Никто не оспаривает необходимость антитеррористических операций для борьбы с существующими в этой области угрозами. Но использование борьбы с терроризмом для борьбы с несогласными, вмешательство в внутренние дела других государств, бомбежек, в результате которых гибнет мирное население, недопустимо. Вызывает серьезную тревогу бомбежки США территории Сирии без решения Совбеза ООН, в результате которых уже погибли женщины, дети, ничем не может быть оправдана американская политика глобального электронного слежения в рамках борьбы с терроризмом. Широкий резонанс вызвали разоблачения Эдварда Сноудена. США осуществляет электронное слежение в рамках программы «Призм». Наносили удары по различным объектам с воздуха при помощи беспилотных летательных аппаратов. Под американским наблюдением оказались 35 руководителей различных стран, считавшихся друзьями и союзниками Вашингтона. Материалы американских СМИ свидетельствуют о значительном ухудшении положения заключенных в тюрьмах. Десятки тысяч заключенных содержатся в тесных, одиночных камерах, без вентиляции и естественного света. Нью-йоркскому фотографу Скотту Хьюстону удалось заснять, что в штате Аризона узники скованы одной цепью и работают так целый день. Правозащитники обеспокоены практикой насильственной стерилизации женщин в тюрьмах штата Калифорния. Вызывает тревогу положение политических заключенных. В тюрьмах за свои убеждения находится свыше 100 человек, многие по сфабрикованным обвинениям. Например, уже 37 лет в заключении находится активист движения американских индейцев Леонард Пельтер. 32 года отбывает тюремный срок афроамериканский борец за гражданские права Мумима Джамал, борец за независимость Пуэрто-Рико Оскар Лопес Ривера и анархист Дэвид Гилберт. Заключенный не получает адекватной медицинской помощи. Призываем американские власти обеспечить, наконец, необходимую медицинскую помощь, включая операцию российскому летчику Ярошенко. Не понесли никакого наказания и бывшие сотрудники Минюста США, санкционировавшие применение таких методик, как длительное лишение сна, заключение в ящике с насекомыми, принудительная нагота, имитация утопления. Президент США так и не выполнил свое обещание закрыть тюрьму Гуантанамо, в которой годами практикуется бессудное содержание заключенных. До сих пор не проведены полные расследования, не были привлечены к ответственности виновные позорной для Европы практики организации секретных тюрем ЦРУ. В этой связи хотели бы упомянуть недавнее решение суда по правам человека по делам Аль-Нашир против Польши. Отдельно хотелось бы сказать и по вопросу отмены смертной казни. В стране, позиционирующей себя как эталон демократии, используются неправомерные медицинские препараты, превращающие казнь в жестокую мучительную пытку. Вопиющие нарушения прав человека должны быть предметом постоянного и самого пристального внимания со стороны ОБСЕ. Со своей стороны хотелось бы еще раз подтвердить приверженность Российской Федерации принципам международного права и готовность к дальнейшему сотрудничеству. Спасибо.
Thank you, sir. I give now the floor to the United Kingdom, to be followed by Area Eurasia. United Kingdom, you have the floor.
Thank you, Ms. Moderator. We align ourselves with the statement delivered by Denmark on behalf of the European Union and would like to add to it with some of our remarks in our national capacity. The United Kingdom attaches the highest importance to the rule of law as a cornerstone of democracy. We would like to make the 5 following recommendations related to this working session. All OSCE states should sign, ratify and implement the UN Convention Against Torture and its optional protocol. Governments should demonstrate a high degree of political will, persistence and vigilance to prevent torture and to bring perpetrators to justice. Governments should ensure that allegations of torture are effectively investigated and prosecuted. There must be no impunity for torturers. States should support the strengthening of civil society capacity to monitor torture allegations and ensure strong domestic institutions. States should consider the development of national torture prevention strategies. The UK considers torture to be an abhorrent violation of human rights and dignity and consistently and unreservedly condemns the practice. Preventing torture and tackling impunity for those who torture are essential components of safeguarding our security. It is integral to fair legal systems and the rule of law. Torture prevention is a UK human rights priority. The Foreign and Commonwealth Office's Minister for Human Rights has an expert advisory group on torture prevention, and we have a comprehensive strategy for the prevention of torture. To protect against possible complicity in torture, the United Kingdom has strong measures in place to ensure that when an official has knowledge or belief that torture will occur, this will be reported to government ministers and their concerns will be raised with the detaining authority, unless doing so might make the situation worse so far as the detainee is concerned. We support the Swiss chairmanship's efforts this year to refocus the OSCE's attention on torture prevention and their intention to seek consensus on a ministerial decision that broadens and strengthens the OSCE response to this aberrant crime. Madam Moderator, the UK campaigns globally for abolition of the death penalty, and it is our long-standing policy to oppose it in all circumstances as a matter of principle. We consider that its use undermines human dignity, that there is no evidence of its deterrent value, and that any miscarriage of justice leading to its imposition is irreversible and irreparable. When it comes to the issue of protecting human rights in combating terrorism, my government is clear. We must deal robustly with the threat of terrorism and extremism in all its forms. In doing so, we will ensure that any actions are in line with international obligations and consistent with our proud tradition as an open, free and tolerant nation. I thank you for your attention.
Thank you, sir. The floor now goes to Aria Eurasia, to be followed by the Committee Against Torture.
Thank you.
You have the floor, sir.
I'll begin my speech in Russian and continue in English. Стыдись, свободная Европа, что был у вас такой премьер на побегушках у казахского диктатора Тони Блэр. This is part of poem by Aaron Atbeck written in prison. I want to focus now on tortures applied to Aaron Atbeck in prison, and as we have no mechanisms to help him inside the country, I want to call OSCE and ODIHR to focus on the problem of political prisoner sentenced to 18 years in Kazakhstan. Currently, Aaron Atbeck